he made a decision that he would go and recount because that was a very small percentage of the entire recount process. But then he went up with 1, 2, 3, up to 10 boxes. And again he insisted on recounting and again declaring someone out of such a sham procedural matter before him. So we think all these things need to be checked.
Eno wini ejiddemu ekisa kya Katonda, ejiddemu omukisa naye ate era nkolerere abantu baffe mbabeereddewo era mbabaddemu. In fact abantu b'e Masaka City nze be bansaba okwesimbawo ku bwawuma n'empi Masaka City nga bagamba nti Honorable byokola byonna n'enjiwawo gy'oyiwawo omubiri ku lw'abantu osaana kubeera mu Parliament. Ne bagenda ne bampa akalulu.
Council, first of all, we want to welcome you from Masaka. We saw what happened there.
No, I'm still in Masaka.
You are still in Masaka.
Because the battle still goes on, especially when you are fighting the judicial officer who we think mishandled the matter of recounts in Masaka. Not even one that we are talking about. He mishandled basically all the applications which are there, and we think he should be really taken on for judicial misconduct. Judicial misconduct in such a way that he exercised jurisdiction which he does not have. He exercised jurisdiction in excess of the jurisdiction he has. First of all, when he had matters which were incompetent before him, when he had matters which had expired before him, when he had matters which are not for him but for the High Court. For example, he did not have first the powers and mandate to hear an application which was filed late. He did not have the powers to hear that application was outside 4 days. That matter took up to 9 days. You just imagine matters which are supposed to take 4 days. If at all he had started with the matter of Namere and Nalubowa, it means that applications ought not have been heard because they would have been overtaken by events because they would be outside the 4 days. All these issues show you that if you do not follow the law, it catches up with you. If you do one mistake at law, it finds you at another step. You'll find that even having ordered that he will not proceed with the recount, upon finding any of the ballot boxes tampered with, he decided to proceed with the recount after finding a box without the seal. He made a decision that he would go and recount because that was a very small percentage of the entire recount process. But then he went up with 1, 2, 3, up to 10 boxes. And again he insisted on recounting and again declaring someone out of such a sham procedural matter before him. So we think all these things need to be checked. He cannot hide behind the judicial clock and immunity when he's performing things which are glaringly wrong at law, wrong at procedure. It's not excusable because he has put the whole judiciary at shame that you can now just casually wish away the rights and the decisions of voters in Masaka City just like that. He cannot go unabated. We think we are going to take him on. We are going to find means of, first of all, challenging his decision before court, before the High Court, and also we need to really tell the judiciary through the Judicial Service Commission that such judicial officers need to be brought to work. We filed a revision an application in the High Court of Masaka with a view to having all those decisions which were wrong at law set aside so as to maintain the Honorable Rose Nalubowa as the elected Member of Parliament, woman Member of Parliament in Masaka City.
How far with that?
The appeal by Rob revision was filed and save for the fact that judges have been in a judges conference, probably that's what we are waiting. Immediately they are post which are seek for injunctive orders so that the decision and its orders and declarations are stayed until the matter is heard substantially. We do not want to envisage a situation where Namere has gone to Parliament even for 1 day. So we are trying to curtail that, and the judiciary has to join hands with us in ensuring that justice is done in favor of Nalubowa Rose, because if they delay in this matter, Nalubowa and Namere goes on to swear, then there will be damage. We are doing everything possible, and we believe the judiciary should really come out very strongly to facilitate our application so that it is not rendered useless.
What could be your words to Magistrate Asimu?
No, I would not want to make it an Asimu affair. To all judicial officers. The judiciary should liberate itself. Because now we know for a fact that why he did all that he did is because he had heard what President Museveni had complained. So President Museveni was a complainant that some of his votes may have been stolen in Masaka, and that he believed that a few people having won at local levels, then NRM was still strong, and people like Namere ought to have won. So it was kind of a directive from the president. That is interference by the president into the affairs of the judicial arm of government.
We saw a lot of deployment, SFC.
Yes.
Did you?
SFC was in charge. The Electoral Commission was not in charge. The returning office had been transferred. You realize it's so peculiar that it's such a matter where the chief magistrate was new. The one who was there had been transferred. Chief magistrate knew. The returning office had been transferred. We had an acting returning office, a caretaker returning office actually. You had an RPC who was in charge of security, also transferred. All these were transferred and new ones were brought just for purposes of fulfilling a mission to ensure that Namere or other NRM candidates are in parliament in one way or another. So that was wrong. It was politically instigated, and we think this is not how things should. People should be left with their right. At least they are the right they have left with in this government is at least to vote their leaders. That should be preserved.
In the case of Ngomangine versus Bini Byanyuma, we well known that this was illegal. If this precedent stay,
not on Ngomangime alone. Ngomangime was 2001. Along the way, Ngomangime has been referred to in so many other cases, and jurisprudence has been developed to say that once you find any box tampered with, then the entire process is contaminated. To give a comparative, to compare it to a given scenario, comparative scenario is that, for example, if you have a sieve, like it was said in Omanjime's case, that a recount is a sieving process to disentangle numerical issues. So if it is to be a sieve, if you are sieving water and you see dust on the sieve, you would not say that this is small dirt or the other. The water is dirty. So even if it's one ballot box, 2 or 3 or 4, it does not matter. The issue is the process is contaminated. It cannot produce a healthy result.
What's your prayer to the judiciary? Basically, the Chief Justice, the new Chief Justice of Uganda, Dr. Flavian Nzeija, about this case, and what's the procedures if they are to discipline the
rule of law? We just want everyone to follow the law. The person who doesn't follow the law, it doesn't matter whether you're a magistrate, whether you're a judge, if you are under the law. Everyone should not be above the law. It doesn't matter if the law catches you on the wrong side of it. Even if you're a magistrate, you should be